12th February 2025, Indian Express. The first headline is In Proposed Immigration Law, Tougher Roles and Specifications. The Immigration and Foreigners Bill 2025 is likely to be introduced by Union Home Minister Amit Shah in the ongoing budget session of Parliament. The proposed legislation will replace the existing laws, the first one being the Passport Entry into India Act 1920, second, the Registration of Foreigners Act 1939, third, the Foreigners Act 1946, which was enacted to confer the central government with certain powers in respect of foreigners, the fourth one being the Immigration Carriers Liability Act 2000, which was enacted to make the carriers liable in respect of passengers brought by them into India in contravention of the Passport Act of 1920 and its rules. The first three of these acts were pre-constitutional and were brought during First and Second World Wars. The key provisions of the new act are penalty up to 5 lakh for unauthorized entry and up to 10 lakh for fake passport, provisions relating to obligation of universities, educational institutions, hospitals, etc. on admission of foreigners, all immigration control under one agency, foreigners cannot change names without nod. The second headline is In a New Nation when abolition of Zamindari system was challenged in Supreme Court. Shankari Prasad Deo, Zamindar from Kashipur, moved the Supreme Court challenging the new nation's first plank revolution, the abolition of Zamindari system. The Patna High Court struck down an act as unconstitutional because it abolished Zamindari, and the court contended it violated Zamindar's right of equality. The act was Bihar State Management of Estate and Tenure Act 1949. In response, then Prime Minister Nehru, even before challenging the ruling, brought the First Amendment. Among other changes restricting free speech and caste-based reservations, it also introduced Article 31A and 31B. It provided that no land acquisition law would be deemed void on grounds that it violated any fundamental rights. The second provision brought in Ninth Schedule and Bihar Land Reforms Act 1950 was added to it. Laws placed in the Ninth Schedule cannot be challenged for violation of fundamental rights. Shankari's arguments were not directly against the land reform law, but wider implications of the First Amendment. Did the Provisional Parliament pending the first Lok Sabha elections have competence to amend the constitution? Even if it did, Parliament could violate Article 13 Clause 2, which prohibits making laws that would derogate fundamental rights. On October 5, 1951, a five-judge bench of Supreme Court decided in favor of the government. They textually interpreted, the Supreme Court said they could not make a statutory law derogating fundamental rights, but an amendment can be made. In 1967, Supreme Court reversed the ruling. However, the debate on right to property was not settled. Finally, in 1974, in the Keshavananda Bharati vs. State of Kerala case, it was held that even constitutional amendments cannot violate basic structure, which includes fundamental rights. Land reforms passed the test since right to property was not deemed to be part of the basic structure. The third headline is President's Rule Among Options for Manipur, the Provision and its History. N. Biren Singh resigned as Manipur CM. If party fails to find a consensus CM candidate, the state may have to be put under President's rule. It has been imposed 134 times across 29 states and union territories. Article 356 of the Constitution deals with it. The most recent imposition was in Puducherry. In the case of S.R. Bomai versus Union of India, a 9-judge bench unanimously held that the power under Article 356 was subject to judicial review. The fourth headline is South Sudan displaces Somalia as most corrupt nation. Transparency International, which compiles the annual Corruption Perception Index in the index, found that at the first place, that is the least corrupt nation, is Denmark, the last is South Sudan, and India ranked 96 out of 180 countries.